minutes of rebuttal, please let me know and we will accommodate you. Our first case this morning is Sedlock versus State. Good morning.
Good morning, Your Honor. May it please the Court, my name is Mihaela Kabulea and I represent the appellant Joseph Sedlock. I would like to reserve 5 minutes for rebuttal. The main issue in this case is whether after medical marijuana became legal in Florida, a dog alert can still provide probable cause for a search incident to a lawful traffic stop. Although this very specific issue was not raised below, we argue that this is fundamental error and can be reviewed by this Court in this appeal because it amounts to a constitutional violation. The case presents a relatively straightforward factual scenario. In November 2017, Mr. Sedlock, at approximately 7:30 p.m., rode his bicycle in front of two police cruisers very suddenly. One of the first police officer driving the first car noticed that Sedlock didn't have headlights on, lights on his bicycle, and also the abrupt turn in front of the police car that caused the cruiser to, the officer to brake abruptly. So decided to perform a traffic stop. Behind him was another officer, and the two of them, one of them conducted the traffic stop and the other one decided to conduct a canine search because allegedly they noticed that Mr. Sedlock was nervous. So the
Could I ask you a question?
Sure.
Looking at the motion to suppress
Yes.
filed by trial counsel, exactly where in the motion would this basis for suppression have been raised?
Well, that's what I just said. It wasn't raised and it wasn't preserved, but we argue that it's fundamental
error.
Fundamental error, and this Court can review it because it amounts to a constitutional violation. So one of the deputies initiated the canine search, and the dog sniffed the bicycle. The bicycle seat didn't alert to the bicycle seat, didn't alert to the bags on the bicycle, and then thereafter the dog walked around the Mr. Sedlock, and it didn't alert to the left pocket where the methamphetamine was found later, but it did alert to the right pocket where the cannabis was found.
Now remind me, they deliberately had the dog sniff your client.
Yes.
Okay.
They did that. And without initially finding any indicia of suspicious activity, the dog didn't alert to the bicycle, the dog didn't alert to one of the pockets, only to the other one, and the officers didn't notice absolutely anything suspicious about Sedlock.
Did he say that it was acting nervous?
Yes, Your Honor, but honestly, who wouldn't? It's in the evening, stopped by two police officers, and you have a canine dog on the scene. So everybody, I mean, pretty much everybody would act nervous. They didn't detect any kind of drug use or impairment or anything, and
The stop was legal, though.
the stop was legal, yes, and it wasn't disputed below, and it's not in this appeal. It hasn't been raised, so the stop was legal. And at the same time, when
Was the dog sniff search of the pocket legal?
Sorry?
Was the dog alert on the pocket a legal search? I mean, a legal part of a legal detention?
Yes, we argue that it was because
So we're to the point now, the question is the marijuana that was found. The
Right.
argument is that to establish probable cause, it's the state's burden to show that a reasonable person might conclude that this was medical marijuana. And so I guess my question is, if it's medical marijuana, if that's the argument, would that be in the nature of an affirmative defense? That is, I admit that I had marijuana, but I lawfully possessed it. And how, if that is the case, how does that fit into a probable cause or reasonable suspicion analysis under the Fourth Amendment jurisprudence?
well, to begin answering your question, I would like to point out that the only reason why a dog sniff is allowed incident to a lawful traffic stop is because it's so precise in nature, and it has been addressed by the United States Supreme Court. It has been described as a very narrow investigative method. And that is...
Minimal intrusion, I think.
Exactly. Because, and specifically because it is capable of detecting only illegal substances. Now, we have, in this case, after the medical marijuana became legal, we have the possibility of a dog detecting legal activity. So how is now possible that without more, a dog alert can provide a indicia, probable cause to search someone based on criminal activity? It doesn't anymore. And that is our argument, and that is why we argue that this dog search was not justified and it amounted to an illegal search because there was nothing else in addition to the dog sniff and the dog alert that would have justified the officers to search Mr.
If a
Sedlock.
police officer stops someone and is aware that this person was a convicted felon and they're carrying a firearm, is that probable cause to make the arrest, and then you find out later by proof the affirmative defense is, I've had my rights restored and I'm able to carry a gun now. Does that invalidate the stop and the search, or does it bar a conviction?
Well, that's slightly different because there we have probable cause. So,
Well, isn't that the question here, whether the search, the sniff gives you probable cause? And is this an affirmative defense of medical marijuana that would allow you to bar a conviction, but doesn't necessarily impair a probable cause analysis?
I beg to disagree, Your Honor, because
No,
I think...
I haven't figured out the answer yet. That's why I get to ask you questions, because you're all well prepared on this, and I'm just working my way through it.
Because as I said, the dog sniff itself, without more, does not provide that probable cause anymore. It can alert
They sniffed
to...
him, they patted him down, and they found the marijuana, right? In the pocket.
Right, but
And they
that's
found
an
the meth
illegal
in the other
search.
pocket. But why would it be, you're saying it's illegal because they didn't disprove that he had authorization to have it, i.e. medical marijuana. Is that the argument?
No, the argument is that to begin with, the search was illegal because we can no longer trust a dog sniff to be that precise in nature and without anything else to justify the search. So I'm arguing that a dog sniff is no longer what it used to be.
The dog sniff case went up, I think, to the U.S. Supreme Court, and a case that started out of our court, if I recall correctly, authored by Judge Northcutt, about the level of training that the state might have to show in order to show the dog's olfactory senses work properly. Supreme Court said, you know, you've got training and stuff, and that's pretty much all you need. And this dog, apparently, no one challenged the dog's ability to alert on this substance. There was a pat down, and it turned out to be a green leafy substance. So it would fit in most of the constitutional doctrine that we have now had established over the years. And I don't want to say it was Florida versus Jardines, but there was a couple of cases that went up at that time. So what I'm trying to find out is, what is the burden you are asking the state to now show in order to make the sniff a valid, you know, the search of the pocket based on a dog alert invalid? Do they now have to train a dog to know that there was medical marijuana? I don't know the dog can read that receipt.
Well, I mean, in order for the search to be as narrow as the Supreme Court decided it was, it would have to be able to distinguish between what's a legal substance and what's an illegal substance. If there is nothing in addition to trigger probable cause. Like the case the state is relying on, one of the cases that the state is relying on, Rem versus State, has a relatively similar bike scenario in which the defendant was riding a bicycle, was stopped by the police officer, and again, without the light, and was stopped. The traffic stop was legal. The officer noticed signs of impairment in the defendant in that case and asked if he can conduct a search. The defendant declined, and then a canine unit was summoned right away. And once the canine unit came, it alerted to the bicycle handle and the bicycle seat, but then the officers did not have the dog sniff the defendant, but conducted a search on the defendant. And the state is arguing that that implies the fourth DCA meant to say that that the police officer could just have the dog sniff the defendant himself. But our position is that without the fact that the defendant in that case appeared to have some drug usage and there was some additional probable cause, maybe that's what triggered the fourth DCA to say that the police officer should have had the dog sniff him. But in any event,
with a bike, I mean, your typical dog sniff of a car, the dog alerts at the car, you remove the occupants, then you search
Right.
the car.
exactly.
Okay, with a bike, you know, if all I'm talking about is a bike, a seat, two handles, you know, there's nothing, there's going to be limited occasion where there's much to search on the bike. So doesn't it make common sense that if the dog alerts at the bike, you've got probable cause to detain and search the fellow riding the bike?
Well, I agree, and that's what the fourth DCA found in that case. And there is no probable cause based on the bike itself. And in that case, the police officer didn't have the dog go around the defendant. But here, it's very different. The dog didn't even alert to the bike. And this very court in another case that we cited in our brief, State versus Tenor, has affirmed a suppression of the evidence where the occupants of a vehicle were stopped. It was, again, a lawful traffic stop, and then the defendant was the occupants were asked to step outside, and then one of the defendant herself was reluctantly made to leave her purse in the car. And this court found that and later on, illegal substances were found in the car, and this court found that the evidence was properly suppressed because there was no reason to take the purse, to make the defendant leave the purse in the car. And the only thing that was authorized under the law was a sniff of the car itself. So there's really no authority for a dog sniff incident to a lawful traffic stop of a defendant himself or of an occupant of a vehicle, him or herself. I did not come across any such case, and the state didn't cite to any of such cases that would support a search without more, without any other indicia that there's some illegal activity happening here. So based on this, we would, if there are no more questions from the court, I would like to reserve the remaining time for the rebuttal, and
I'll give you 5 minutes.
we would ask this court to reverse and remand the.
Thank you.
Thank you.
May it please the court, my name is Lindsay Sims, Bone and Steel, the Office of the Attorney General, and we represent the appellee in this matter, the state of Florida. Initially, in preparation for this oral argument, I noticed that there is a scrivener's error in the judgment in this case on page 35 of the record of appeal. On this misdemeanor count 2, which should be the possession of marijuana charge, it reads possession of paraphernalia pursuant to 893.147, rather than possession of cannabis pursuant to 193.13 subsection 6, as indicated on the information and the plea form in this case. And I bring that to the court's attention for the purpose of correction.
Has anyone appealed that issue?
No,
Do we know if there's a 3800 filed below?
I'm not aware that there is,
Okay.
Your Honor.
Thank you.
Where was the defendant when the dog alerted I would assume he stepped off of the bicycle, ma'am?
You know, this is a case in which the motion to suppress hearing was very short, and there aren't a lot of facts. Or a lot of
Would that make a
details in this
difference?
case.
Would it make a difference if the person was on the bicycle? In other words, analogous to inside the vehicle when the dog alerted?
Yeah, I think it would make a difference, Your Honor, because we wouldn't necessarily be able to distinguish, given that it's a bicycle, between how the dog alerted on the bicycle or on the person.
That's where I'm getting at here.
Right, the scope would be the same. What we have on the facts of this record is that Deputy Molina says he conducted the search while the defendant was standing behind the bike. The bike is kind of in front of him. And we don't know if that's a large distance or short, but he describes the dog going around the bicycle and then going around Mr. Sedlock. So we
Does
don't know.
our record disclose what the effective date of the constitutional amendment was?
No, Your Honor.
Was it in the election of 2018 that the Constitution was amended?
I believe that it was in the summer of 17. And this was this search was in the November.
When is its effective date? Because this stop took place in November 17th of 2017. If the constitutional amendment wasn't effective at the time, why would we get to it after the fact?
I don't know the answer to that, Your Honor, but I would supplement if you wish me to do so. It was my understanding that medical marijuana was made available in the summer of that year.
Okay, then it may predate the stop. Okay.
Yeah, that was my belief, my understanding, Your Honor. It's the state's position that that this issue was not preserved by argument below. We would also note that in the alert, you know, we have this information, this facts on the record. The dog goes around, the dog alerts at the pocket, but we don't know really, because it is a pair of shorts with pockets, if the dog is particularly responding to the odor of marijuana or to the methamphetamine. It's unclear. And probably in other cases that we've seen, we don't see a laser scope on the point at which a dog alerts that would distinguish between perhaps a marijuana area as opposed to a nearby methamphetamine area. We would submit that the medical marijuana law is not legalization of marijuana in Florida, and it is a factor in a totality of the circumstances decision about probable cause. But it's not a blanket prohibition on a finding of probable cause. The case law that's relied upon appellant.
Is it in the nature of a legal affirmative defense to the arrest charge, or does it somehow, the argument from the defense is that it factors into determination of probable cause? Does it factor into probable cause? Does it factor into only guilt or innocence by reason of affirmative defense, or can it factor into both? What is the state's position?
The state's position is that it's both. Certainly it's an affirmative defense, but it also is a factor in probable cause, particularly given the Florida statutes that have packaging requirements for the medical marijuana, and the fact that up until recently, within the last few months, the smokable that's not oil, the leafy type of marijuana, was not even legal as medical marijuana in Florida. So we have that consideration of probable cause. What does the smell? What does something look like? What does this dog alert to? Would all be in a reasonable officer's mind in consideration of whether there is a belief that criminal activity is afoot. So in probable cause, there's the element of the circumstances at the time, and also there is the registry. A registry card might dispel probable cause at the scene. Certainly, the touchstone of the Fourth Amendment is reasonableness. There are, the state has a strong governmental interest in enforcing the drug laws of Florida. In addition, we would also know that there's a relatively small number of medical marijuana patients. According to the Department of Health in January, it's something like...
How do we know that at this point in time? Is it in our record?
It's not in our
Has anyone
record.
asked us to take judicial notice of that fact? I mean, my concern is what's in this record here to reach the legal conclusion.
Well,
And
in
that may
this-
all be, as you say, appropriately, but no one, and part of it's the reason it wasn't really raised below.
Correct, Your
You know,
Honor.
no fault to the judge or anybody else, it just wasn't raised below.
Correct, Your Honor. As to the issue with the state's reliance in the REM case, the state's reliance on REM is merely to point out that here in a bike stop scenario where they have, and I think this goes to Judge LaRosa's question, where you have a stop on a bike, a bike stop with a dog alert on the bike, but they're not finding drugs on the bike, without a canine alert on the defendant himself, there wouldn't be the probable cause to search. And our position is just that the Fourth District Court of Appeal recognizes that there is a possibility that they might have a dog alert on the person as well that would factor into the analysis. If there are no further questions...
I have one. I know you would like to sit down, but the thought just occurred. This came by reason of a constitutional amendment, is that correct?
Yes, there's a constitutional and also
So if there's a constitutional amendment that says you have now a constitutional, in the state of Florida, right to possess marijuana for medical purposes, how does that constitutional right interact with the constitutional right you have to be free from limited intrusions from the government? Does it now say that, the government is going to have to make adaptations to this new constitutional right, and all the jurisprudence that we had before doesn't, because the people of the state of Florida have said you have a constitutional right to have the limited right to possess marijuana for medical purposes. It's not just a statutory right or possessory right or lack. It's now raised to a constitutional right. How does that impact our analysis? Can we tell at this point?
The constitutional, let me just say, the constitutional right is not something that is applied to all Floridians. We all have the right to apply for it, but the right is only given to certain patients in Florida. So when we think about analysis, the Fourth Amendment, the right to be free from improper search and seizure.
Yeah, but a lot of that is premised on that marijuana, meth, is an illegal drug. There is no constitutional right for you to possess it at any time, under any circumstances. And arguably now, by the vote of the people of this state, they have changed that analytical dynamic and said a certain number of people are constitutionally permitted to have this drug. And how does that impact the analytical equation?
Well, Your Honor, the simple fact that we have this constitutional right applied to certain people, it didn't take away the fact that we have the laws against controlled substances in Florida. It didn't change that law.
The interesting question is, it doesn't take away the federal laws against possession of certain drugs. So there's another layer on top of that, because the DEA or other people can still arrest you for possession of marijuana, right?
Correct, Your Honor. And we have to be cognizant of that in Florida, that even though we have medical marijuana in Florida, these Floridians who have been given this right can't take their marijuana across state lines and expect to be protected. If there are no further questions, as to remaining issues, I would rely on my briefs and ask that the only relief to be granted in this case is to remand count 2 for correction as noted. Thank you, Your Honor.
Thank you. Counsel?
My recollection, Your Honor, is that in count 2, that defendant pleaded as to 2 different cases, not just to one. And the second case was possession of drug paraphernalia, and I'm not sure if, so maybe that's what you saw on the sentencing sheet. So I just wanted to bring to the court's attention that there might be what the AG is referring to might be just a plea to the other case that was possession of drug paraphernalia, because he resolved 2 cases through this particular plea. And to go back to Judge Casanueva's question about how this constitutional right impacts our constitutional right to be free from unreasonable search and seizures, I would like to point out that that's the very reason why we believe this is a constitutional violation, because now we have people in Florida have a narrow group of people, true, have a constitutional right to possess a certain amount of medical marijuana and to possess and use. And we have a system that still allows and touts the dog sniff as an infallible, for as long as the dog has a reasonable training record, an infallible search method that can only detect illegal substances. And a person who is lawfully in possession of medical marijuana can very well be subjected to an unreasonable search because of that. So that's why we argued it's a constitutional violation of Mr. Sedlock's rights. And I'm not saying that in every and all particular cases that is the case, but under the facts of this case, when there was nothing else to point out to the fact that Mr. Sedlock was engaged in illicit activity or drug use or was impaired in
Let me
any
go
way.
back to your earlier statement. You said this was a violation of Mr. Sedlock's rights. Has he made any demonstration, as a matter of fact, that he falls within this class of people to which this constitutional amendment affords a right?
Well, actually, Your Honor, Deputy Molina said he never asked him whether he was in possession of a medical marijuana card, and because it didn't occur to him.
The deputy didn't ask, and your client didn't say.
No.
Okay. No, that's not true?
No, he didn't say.
Okay.
Right, that's what I meant to say.
Okay.
He didn't say. And I wanted to clarify a few things as to Judge Badalamenti's question regarding whether the defendant was on or off the bicycle. The way the deputies testify indicate that he was off the bicycle because the dog went around the bicycle first and sniffed the bicycle, and there was no signal as to the bicycle, the handrails, or the seat. And then the dog went around the defendant, and the Deputy Molina confirmed, and I have some record sites at page 66, 69, and 74, that that the dog did not alert to the pocket where the methamphetamine was, which again strengthens the point that a dog now can alert to legal substances, and it didn't alert to the methamphetamine, because the methamphetamine was in a cigarette box and it was wrapped in cellophane. So we have a dog sniff, a dog alert to a legal substance now in Florida, and we don't have a dog alert to the illegal substance. And
We have to wrap it up.
right, I wanted to say that as to all the other arguments, we stand on our written briefs, and we ask that this court reverse the conviction. Thank you.
Both.